laws made by Congress, which was the only thing that we authorized in those Section 136. What did it say? What are we? Animals, okay? You need to remember Title VII, United States Code, Section 136D. Okay, that's animals. So, Ballantyne's Law Dictionary, 1948, human being defined as follows. See monster. Same dictionary, monster is defined, a human being by birth, but in some part resembling a lower animal. Not even just an animal, a lower animal.
Serpent?
They never said. Okay? So people is defined as, also from Ballantyne's, the state, the nation, any consolidated political body, the subjects or inhabitants of a nation. Subjects are what? Slaves under the monarchy. People of the United States, the sovereign people. Citizens, capital C. Ballantyne's new. Okay? This is an English law dictionary. Okay, I want to talk, this is a short video about the Reconstruction Acts and why we're still under martial law. Go, right?
How many people have heard of the United States? Which one? This has 3 separate legal meanings. Which one are you talking about? Okay. What I'm calling it. Let's see where it is in the middle of this thing. In this case, I can't find it real quick. Like the court said, the United States Supreme Court in Hooven versus Elliott. No, that's the wrong one. It's Hooven versus EVAT. It's on the Patriot newsletter over there. Hooven versus EVAT. Hooven versus EVAT. EVATT. You can get a direct code off the paperwork over there. In there, the United States Supreme Court held that the United States has 3 separate, distinct legal meanings. One, it means a nation amongst nations under international law. One, it means the District of Columbia and the territories over which the United States is sovereign. And the other one, it means a collective name of the sovereign states and the federal government included. The collective name. Which one are they? Which one bring charges against me? You do your admissions. I don't understand the meaning. The court says this. You write them a letter and say, the court says this. I want to know which meaning of the United States you're talking about here. And they got to come back and tell you. Do your request for admissions. And if you want to be really, really nasty, I can teach you to do that too. You write a letter to the government, and first you write your first letter to the CRS. That's Congressional Research Service in Washington, D.C. And you ask them, are the Reconstruction Acts, have they ever been repealed? They can write back and say, no, they've never been repealed. Then you write them a second letter. If that's the case, under the Reconstruction Acts, all the states lost their sovereignty. And we're now federal territories and federal enclaves under the Reconstruction Act, under martial law. Is that correct? And I can write back and tell you, yes. You don't put all your eggs in one basket. And you have to write it the second letter. The third letter, I mean. Didn't you say, is the president signing these executive orders as he's signing them under the authority of the Reconstruction Acts, under martial law. And they'll say yes. Now you got it. You take those 3 letters, IRS come after you, or you want to go after them, or whatever, bingo. We're under martial law, you know what I mean? The wartime footing. See, you set them up. You do one step at a time. You do a letter writing campaign. Steve knows pretty well how I do letter writing campaign. Very effective, aren't they?
Yes, they are.
Okay. I'm going to stop it there because he gives some more explanation. But with those letters, he has proved where everybody says, well, it's the gold fringe on the flag. It's not the gold fringe. It's the Reconstruction Acts and the orders that presidents are signing. They are not orders under our system of government. They are orders under military law. Military law, where they said Order 100, right? General Order 100. Military law that was set by an unlawful president.
Not at all.
Oh, I'm sorry. Apologize, thank you. They were waving at me at the back. So what he was saying was that those 3 letters that he got from the Congressional Research Service, which you can still ask and they'll research it, is that the Reconstruction Acts were still enacted, they hadn't been repealed, that the Reconstruction Acts themselves are what we labor under, and that the authority for the president to do executive orders, to execute executive orders, is the Reconstruction Acts. The Reconstruction Acts were enacted in 1867, 66, and 67. In that enactment, we didn't have an actual sitting government or an actual sitting Congress because we had an unlawful election with an unlawful president that unlawfully ordered the Lieber Code or General Order 100. So in knowing that and knowing that you're a people, you can always come against the empire, and you can always come against any court. All courts are tax courts. The meaning of bench is bank. And anytime you have a single judge sitting there, that judge is an administrative banker, not a judge, not a court. They're courts of contract. They're called courts of contract. They are not courts of record. Okay? So also in that, what you need to know about Texas is that every judge, no matter what they call themselves, judge, justice of the peace, district, whatever, in Texas, every judge is a magistrate. Okay? Magistrate is a very, very important word. The etymology of magistrate is judge, but it's under theo, not theo as its root. Theo is judge, but theo is the root for religion. It is not the root for deity. And it literally says that theo is the root for God. Okay? And God is not the word you think it is. Okay? I'll leave that for the moment. Okay, so the important thing about this and the Reconstruction Acts is what in 1869, Ex parte McCardle came before the Supreme Court. And Congress did not want the court to strike down the Reconstruction Acts. And so Congress, now get this, Congress repealed habeas corpus to eliminate the Supreme Court's jurisdiction over the case. Okay? That's significant. As long as habeas corpus is repealed, the Supreme Court actually has no jurisdiction over any case it ever hears. Because nobody can get themselves out of the jurisdiction. That's what habeas corpus is. Produce the body. That's what it means. Produce the body.
Now I want to stop right there and just let you guys know that is where the exclusive jurisdiction of equity comes in. Article 3, subsection 2, subpart 1. And you're looking for a qualified chancellor or group of chancellors to enter into star chambers, which is a rarity. Had it not been for a number of my mentors, I may have never discovered this. And I'm very fortunate to be able to articulate it to you because it pertains to trust. It pertains to the administration of grace exhibited and granted by the Heavenly Father. In the exclusive jurisdiction of equity in star chambers, you are dealing with no lawyers. An attorney is not allowed to speak in there. You see, their only job is as a broker to go in there and settle the accounts and the affairs and bring all rights, titles, interests, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattels, security, trust residual, trust residue, assets, baggage effects, rents, profits, and proceeds back to the true heir and beneficiary of the estate, which is you. And that's why comprehending and understanding trust law is so important, ladies and gentlemen, because on the one spectrum you have at law, in rem, and on the other side of the spectrum you have private exclusive jurisdiction of equity. So there are two competing realms, and that's what I'm trying to help you guys see. I don't necessarily agree with everything that's being said here, but at the same time, you know, grab the meat and potatoes out of it and toss the bone, all right? Grab the golden nuggets out of it and disregard the rest. So with that said, we'll continue on.
Well, when we go to court, is a body ever produced? Who did I hurt? Where's the body? What people did I hurt? What property did I hurt? Where is it? Well, habeas corpus is still repealed. And because of that, they don't have to produce a body. When you go in, does the actual defendant or the actual plaintiff actually show up in court? Right? They hire some attorney.
I'm not so much looking for the plaintiff, which is a fiction, as I am looking for the real party of interest, or that has interest in said subject matter. That's what I'm looking for. The man or woman bringing forward a claim, not a complaint.
To represent them, who witnesses for them. Attorneys can't bear witness. Attorneys can't testify. But that's what they do every day.
And if you don't know how to find the information she's talking about, I would strongly encourage you all to go check out Trinsley versus Pagliaro. Trinsley versus Pagliaro states that a court cannot reach a summary judgment based upon hearsay, which is the only thing a lying, looting, pandering piece of crap lawyer can bring forward to the court is hearsay. They don't have firsthand perfected knowledge of anything. So everything they say should be stricken from the record, and they should be removed from the court, and the real party of interest should be brought forward to state their claim so I can provide relief as an honorable man.
The real parties in interest are never there. You're there because you're defending, right? You're defending your estate. But the real parties in interest never show up. Why? Because they're the bankrupts.
So, because there's no real party of interest, the only thing that this court case can be is a constructive trust, ladies and gentlemen. Now, being able to identify that helps you gain the ability to be able to enforce it. And I am not obviously the trustee of this matter, as this court may presume and assume, but rather the heir and beneficiary of the rents, profits, and proceeds, the rights, titles, and interests, the dividends and derivatives. Okay, everything utilized to monetize this situation, I'm entitled to. All of it. I'm not abandoning these securities, whether they're unsecured securities or secured securities. I am here present and now, not in the fictional realm, but as an heir to what has been created. H-E-I-R. Everything belongs to me. Now, they may give you a little bit of flack, but here's the adverse side of that coin. Ladies and gentlemen, They took estate property, which is a form of identity theft, and they utilized it to generate securities in your good name, pledging you a surety so your ass can set as an asset in jail while the bonds secure and mature. Then they turned around and took the prison system and made it a private, for-profit prison system. Whereas while you're being warehoused, you're also generating more income because you're the source of energy. Your life source energy is the currency. It is the value, ladies and gentlemen. And they come under and use the guise that it's for your benefit. You're accepting a benefit. It's a benefit to be in jail, and because of that, we have to charge you up to stay at our hotel. So we charge up your estate because they know that there is no such thing as money in their false and fictitious monetary system.
They're the debtors. They want you to take on their debt, and that's what court is all about. You're contracting to take on a corporate debt that you don't own.
So what can one do? One can deny the beneficial interest of being warehoused as surety and place that upon the warden, the sheriff, the alleged judge, the prosecutor. Let them sit in the jail if it's such a privilege and an honor, if it's such a benefit. Give them that benefit under the Power of Appointment Act of 1951 and appoint them fiduciaries over the matter to settle the books and the accounting and make sure that the beneficiary has not caused any harm, injury, damage, or loss, and indemnify them just in case they do, so they don't have to go to jail. You know, according to the Bible, we're supposed to forgive our trespassers as they forgive our trespass. Just the same, we're supposed to forgive our debtors as we forgive them of their debts to us. And so that's the significance of that all caps created birth certificate estate, is surrendering it. Get 10 of them. Surrender them. Surrender them to the state registrar. Surrender it to the Department of Interior. Surrender it to the Department of the Treasury for the United States. Surrender one to Washington, D.C., Chief Commander Joe Bummer. You know, surrender these things. Get rid of them. You can get as many of them as you want, and they are a payment bond. They are a check of sorts. So even if you surrender one, doesn't mean you can't go get another.
Okay, so when you look at, and I've gone through each and every one of the amendments. Oh, this is important, real quick. Okay, the Whiting Plan. Okay, this is the military philosophy, the Lieber Code, all of that comes under. And it was William Whiting, and his work is the war powers of the president and the legislative powers of Congress in relation to rebellion, treason, and slavery. Now, he originally wrote it in 1862. It really wasn't published and distributed until 1871. What else happened in 1871? Washington, D.C. was established. Okay, so now we've got two concurrent events, and this is what Deci talks about, war powers. Okay, Whiting really did it in. If you can slog through Whiting's book, you will see exactly the blueprint for what's happening to us under war powers. Okay, I want to flip through these really quickly. Here we go. Federal Reserve. Okay, and what I did, I went through the, this is the other big thing with the Supreme Court. Not only do they not have jurisdiction because of habeas corpus, they decided to include the doctrine of the selective incorporation doctrine. So they acknowledge some of the...
So in a court, how would you effectively... What becomes the question is how you would effectively get into Star Chambers in the exclusive jurisdiction of equity, and it is literally this simple, as Henry R. Gibson clearly outlines, as well as Joseph Story, that one of the the ways to get into the exclusive jurisdiction of equity and star chambers before a chancellor who's qualified under Article 3, subsection 2, subpart 1 would be to plead the conflict of variance between the rules of equity and the rules of law. And if there should ever be a conflict between the rules of law and the rules of equity, the rules of equity shall prevail. So if you're trying to get into the exclusive jurisdiction of equity, one of the surefire guaranteed ways to enter into those chambers is to make it a matter of property. The issue before the court is not about right and wrong. The issue is about property. What property do I speak of? The estate, the Social Security account, the birth certificate estate. That's what it is. It's about property. It's about rights, titles, and interests, ladies and gentlemen.
Amendments when they make decisions, but not all of them. And the two that they leave out, most particularly, are the 9th and the 10th, which reserve all the rights of the people. They never select to use those two. So the 9th, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. Amendment 10, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The Supreme Court never includes that in the selective doctrine of incorporation. And so when you go through and you look at each and every one of the amendments to the Constitution from the second 13th Amendment on, you'll notice that up to the 13th Amendment, everything protects the people. It's all about the rights of the people. Everything from the 13th Amendment on is all about the rights of the federal territorial government.